Good evening. Benjamin Sanchez here. This is day 7 of the Legal Grounds 12 Days of Christmas. I hope you all have had a great weekend. I did not want to close this weekend without doing this video. There's an important change coming up in Texas law, in Texas procedure, and it's something that most people who are not represented by attorneys won't know. And in fact, there are going to be a lot of attorneys in Texas who are caught off guard. So it's important that you know what's coming up and that you ensure that you retain the right counsel who knows and is updated with the law. The change is this. In federal court, attorneys have been used to for years having to do what's called required disclosures. That means that when a lawsuit is filed, both sides within a certain amount of time after the answer is filed must disclose certain information and turn over certain documents. That's because the disclosures are required by something called the Federal Rules of Civil Procedure. Texas has not had that. Texas has its own Texas Rules of Civil Procedure, and it has what is called discovery. Before now, no party had to answer or disclose any information without formal requests being made. And so that's how we've done it. And in fact, most pro se defendants didn't even know how to answer discovery or even bothered with discovery. In Texas, however, starting next month, the rules have been changed by the Texas Supreme Court, and now all litigants in Texas are going to have 3 types of required disclosures: initial disclosures, expert disclosures, and pretrial disclosures. And all those are now required by the Rules of Civil Procedure without anybody having to ask for them. And if you don't know what those are and you represent yourself, you could potentially have your evidence thrown out at trial because you failed to abide by the Rules of Civil Procedure and make those disclosures. This is actually going to be very big. The last time we had a big change in discovery rules was years ago, back in 1999. The discovery rules changed and these requests for disclosures came in for the first time. Now here we are about to start 2021, and now instead of requesting information and waiting for information to be requested, both parties are going to have to do required disclosures from the get-go within 30 days of the answer being filed. And there are deadlines for the other disclosures as well. But no longer can you sit back and wait for the other person to ask you questions or not ask you questions. Both parties have a duty to disclose that information timely. So if you are filing a lawsuit, it might be best to have that information ready to go as soon as you file that lawsuit. If you're the defendant, not only do you need to answer the lawsuit, but you have to be prepared to answer those disclosures, to give those disclosures within 30 days of your answer. Again, we have initial disclosures, expert disclosures, and pretrial disclosures. I will actually be starting to teach some continuing legal education seminars to my colleagues and their assistants starting next month. My first seminar on the new discovery rules is going to be given to a local paralegal group. Paralegals are the people who help the attorneys with all of their work, so it's going to be very important. If you have any questions, give me a call. Let me know. Benjamin Sanchez, 713-780-7745. I look forward to speaking with you tomorrow. Have a great night. Bye-bye.